Hello everyone and welcome to today's session. In this video, we will be taking a deep dive into a very important legislation, a legislation that deals with the portrayal of women in media and advertisements. The title of the legislation is Indecent Representation of Women, uh, Prohibition Act of 1986. Now, this act is a key piece of legislation aimed at prohibiting the indecent representation of women through advertisement or publications, writings, paintings, figures, or in any other manner. Before we dive into the uh, provisions and cases relating to the statute, let us understand why such an act was needed in the first place. Right? Now, let's talk about the background and the little bit of a historical evolution of the act. Now, the 1980s in India marked a significant shift in the landscape of media and advertising with the liberalization policy, also called as LPG policy, that is liberalization, privatization and globalization policy. Under this policy, liberalization of media and the gradual growth of the television and advertising industries, there was a noticeable surge in portrayal of women in a very stereotypical or an often seen sensationalized manner. Advertisements, the posters of the films, or the magazine cover pages, and various product endorsements. Increasingly, all these things increasingly featured women in rather and objectified roles. Now, often unrelated to the product being promoted, but they were objectified. For example, a study conducted in the late 1980s by the Center of Media Studies found that more than 60% of print advertisements in popular magazines like Femina, which was a very popular magazine at that point of time, or the magazine like Debonair, used women primarily as decorative or sensual elements. This is something that is still happening. Many a times we see such kind of advertisements or cover pages now and then. But at 1960s, these magazines used women primarily for to sensationalize their magazine rather than an active participants or informed consumers. Now, television commercials like the television commercials also followed similar patterns, especially in advertisements of consumer goods like, let's say, a soap or a shampoo, or let's say beverages, or sometimes even cars, right? Which was totally unrelated to the portrayal of a woman, but cars were were such advertisements in which woman was portrayed largely for just a visual appeal, nothing more than that. Now, this trend coincided with the growing concern among sociologists, legal scholars, and women's rights activists regarding the negative impact of such depictions had on societal perception of women. These portrayals reinforced regressive gender roles and uh, propagated the notion that women's value lays primarily in her physical appearance Now, the National Commission for Women, also called as NCW, which was established in 1992, but influenced by earlier women's movement. Right? This organization, which was established in 1992, later observed that such content not only undermined women's dignity but also contributed to a cultural and kind of a sexual harassment of women. If we talk from the constitutional perspective, then Article 21 of the Indian Constitution. Now, this Article 21 of the Indian Constitution, guarantees right to life and personal liberty. And this right includes right to live with human dignity. Article 19 Clause 2 again permits the state to impose reasonable restrictions. Article 19 is also called as the six golden freedoms, and this right, under this right, Article 19 Clause 2, states can impose reasonable restrictions on the freedom of, let's say, speech and expression. This restriction can be imposed by the state to protect, let's say, public decency and morality. But there existed no direct legal instrument that specifically prohibited or regulated the indecent representation of women in India. Though the constitutional provisions were in place, but there was no specific legislation to protect the dignity of a woman. Right? Laws like Section 292 and 293 of the Indian Penal Code. Now the law has been replaced by Bharatiya Nyaya Sanhita. Previously it was called as Indian Penal Code. So Section 292 and 293 of IPC did deal with obscenity, but these were not tailored or addressed gender specific concerns or evolving media perspective or the media formats. Right? It was in this legal social vacuum that the Indecent Representation of Women's Act of 1986 was introduced. The primary object of the act was to provide statutory mechanism to curtail the depiction of women in manner that was kind of a vulgar or derogative or offensive to public decency. It was aimed not just at mainstream cinema, but mainstream cinema and, let's say, print media, but also extended to, let's say, advertisements and labels, hoardings, or any other form of public communication. Though relatively concise in its content, the Act filled a critical legislative gap. Right? Moreover, this legislative move also aligned with India's evolving international obligation. Right? There was one international pressure, international obligation upon India, to which India complied by enacting this law. Though India formally ratified the Convention on Elimination of All Forms of Discrimination against Women in the year 1993, the principles and the discussions surrounding this convention had already begun influencing Indian legislative reforms by 1980s. Right? This convention's Article 5 specifically calls on state parties to modify social and cultural patterns that perpetuate stereotypes or prejudice based on the idea of inferiority or superiority of either sex, right? Or in other words, discrimination on the basis of gender. The enactment of this act thus anticipated India's future commitment to international gender justice and standards, and this act somewhere somehow laid the foundation for a more uh, settled discourse on women's dignity in public and media space. Now, if we talk about the scope of the act, then the act is of just 10 sections. There are not more than 10 sections in the act. Let us discuss these sections, not all of them, but the important ones. Let us discuss some important sections given under the statute. Okay. These are some of the key sections that I think are important. Apart from these sections, there are more to it that we will be discussing, right? But section 2, which is a definition clause, contains one definition of indecent representation of women, and this definition stands to be the core definition around which the entire act revolves. Now, what is the definition? The section 2C of the statute defines indecent representation indecent representation as the deception in any manner of the figure of a woman or her form or body or any part of a woman in such a way as to have the effect of being indecent, derogatory, or degenerating women, or is derogatory or denigrating the status of a woman, or is likely to deprive or corrupt or injure public morality or morals, is called as indecent representation, right? I'll repeat the important aspects, important points which are highlighted, which are given in the definition itself, definition of indecent representation of women, right? I'll repeat. Indecent representation of women means depiction in any manner, right? Depiction in any manner. First one, depiction. Second one, depiction of what? Depiction of, let's say, the figure of a woman, the form of a woman, the body of a woman, or any of the body part of a woman, right? Third one, in such a way which is indecent in nature or derogatory in nature, right? Or fourth one, which is likely to corrupt or injure public morality, right? These are the four important essentials of this definition, right? This definition is intentionally broad to accommodate a wide range of mediums and the changing social norms. If you look at the definition carefully, it is an open-ended definition, right? Open-ended definition. It means that any kind of an act which the public thinks is immoral in nature may come under the category of this definition, preview of this definition, right? Now, however, this broadness that we have discussed also makes it kind of a subjective. That is, it is considered indecent may vary. Now, what is considered indecent may vary depending upon the time or the place or the culture or the context or the viewer's perception, right? This is something which is debatable. In a high class society, the meaning of decency or morality may be different, whereas in a middle class or a low class society, the definition of decency or morality may be something else. For example, a billboard advertisement for a perfume that shows a woman in a provocative pose with a caption that objectifies her body might fall under this definition, right? That might fall under this definition even when there is no ill intention by the company, right? Or a magazine cover that sensationalizes a female celebrity without her consent can also be considered indecent representation. Or let's say a music video or a TV commercial where a woman is shown only as a seductive figure or to promote unrelated products, like let's say a car or let's say a construction equipment, right, can be scrutinized, can be brought under the definition of indecent representation. Now, if we talk about some judicial interpretations, in case of Avik Sarkar versus State of West Bengal, this is a case of 2014. In this case, the Supreme Court moved away from the outdated heckling test, HICKLIN, heckling test, right? Uh, this test judged material based on whether it corrupted vulnerable minds or not. Right? This test carried out suggested that how to decide the indecent representation, that is whether it corrupted vulnerable minds or not, right? So Supreme Court in this case moved away from the outdated heckling test and adopted the community standards test. This was a new test that was introduced by the Supreme Court in this case. So community standards test, okay, emphasizing that nudity is not automatically indecent unless the intent is to arouse interest or degrade a woman, degrade a status of a woman. Second definition is of advertisement, section 2 subsection A, right? Section 2 subsection A defines advertisement as advertisement means and includes any notice or circular or label or wrapper or any other document, and also any visible representation made by means of any let's say light or sound or smoke or gas, etc., right? So basically advertisement includes notice, first notice, circulars, label, wrappers, or any document, means some kind of a paper, some kind of a document, or it may also include some visual representations, right? Visual representations may be in form of a billboard, maybe in form of a light or sound or smoke or gas or anything, right? Now this is a very expansive definition of advertisement, right? It covers both the traditional media like the printed advertisements or posters, but at the same time it also covers the non-traditional or innovative forms of publicity, forms such as sound and light and gases and holographic displays and all. The intention behind this definition, behind including traditional as well as non-traditional contents within the preview of the definition, is to capture any medium, whether a message or a product, any medium, especially if it uses or rather it misuses women's image, right? All of it can be brought under the definition of advertisement. Let's say, for example, a wrapper on a product, like let's say a shaving cream that uses a sensationalized image of a woman, or let's say a neon light, a light bar, right? The signs that we see behind the in front of the hotels, right? So neon bar light bar signs showing a suggestive female, uh, a seductive female, right? Let's say a sound jiggle in a radio, in a radio ad, which with let's say a vulgar or objectifying lyrics directed at a woman. So a rapper, a neon light, a sound, a jingle, all of these, if they are violating the decency of a woman, right? They are going, if they are going against the public morality, can be brought under the preview of advertisement. Now, this wide scope ensures that content creators cannot circumvent the law by, let's say, using creative or non-print formats to convey indecent messages. Okay. Content creators cannot circumvent the law by using creative or non-printed formats, right? So a wide number of innovative ideas, innovative methods of advertisement can be brought under the preview of this definition. Now the third definition is of distribution, section 2b. Now distribution includes let's say circulation, publication or supply by any means, right? Circulation, publication or supply by any means. This term distribution, this not only targets the creators but also those who, let's say, share, forward, broadcast or distribute indecent content involving a woman. Now this ensures that even if a third party did not originally produce the indecent material, they can still be held liable if they were responsible for its spread, right? So here this definition separates publication and distribution, right? Publication definition we'll see, it is at the point number 4, but distribution is distributing, broadcasting in any way, right? For example, a person sharing objectionable posters or leaflets through social media comes under the preview of distribution. A publisher or a retailer distributing magazines or, let's say, DVDs, right? CDs, DVDs that contain indecent visuals of a woman, or let's say a pornographic video, CDs or DVDs, right? Those will come under the category of distribution. Or let's say a person forwarding WhatsApp messages containing sexually suggestive or sexually explicit images of a woman or videos of a woman or audio of a woman, right? All these WhatsApp messages will come under the preview of distribution, right? So social media, physical distribution, both come within the category of distribution under section 2b. This section has special significance in digital age. Digital age, when the content are widely disseminated very instantly, right? Even retweeting or forwarding such content might come under the category of distribution, right? Might come under scrutiny depending upon the context and the intent behind such distribution. Okay, if the distribution is done with ill intention or for fun, then the section will be applicable. But the distribution is done with good intentions, like forwarding the same message to, let's say, police officials, then it is exempted from penalty, right? It is a good intention. Now the fourth definition is of publication. Section 2d talks about publication. The definition given under section 2d of publication is dissemination of printed or visual matters. Dissemination of printed or visual matters. Now what does it mean? It means it refers to the act of making content available to the public, right? Publication means kind of a production of such kind of indecent material, right? Now, publication includes both textual as well as visual representations. Representations, let's say through books or newspapers or magazines or pamphlets, hoardings, websites, and even the new innovative AI technological digital publications, right? All these will come under category of publication, section 2D. For example, if a magazine is publishing an article with accompanying images that portray women in a sexualized or demeaning manner, the provision will be applicable. Section 2 will be applied. Or a newspaper cartoon that ridicules women using their body or their attire or body shaming, right? That will come under the category of section 2D. Or let's say a website that posts morphed images, fake images of, let's say, celebrities, right? Or other women with an intent to degrade their image, right? Or to exploit them in one way or the other, will come under the category of publication and can be penalized. Now, while the original act was drafted before digital revolution, courts and regulators have interpreted publication to also include online and electronic publication and distributions, right? Now, let's talk about some more key provisions of the statute. Now, section 3, 4, 5, 6 and 7, right? These are some more important sections relating to the statute. Section 3 talks about prohibition of advertisements containing indecent representation of women. Now, what does it say? This section clearly states that no person shall publish, cause to be published, or participate in publication or exhibition of any advertisement that contains indecent representation of women, right? I'll repeat. First of all, it says that no person, it includes, when we say no person, it includes artificial as well as natural person, right? So natural person, man or a woman, or artificial person, that is companies, corporations and all, right? Publication houses. So no person shall, first one, publish, cause to be published, or participate in publication or exhibition of any form of advertisement that contains indecent representation of women. Okay. This provision is aimed squarely at curbing objectification in advertising. Sorry for my pronunciation. But this provision basically intends to cut down the objectifying of women in advertising, a domain where women's images are often misused by the companies and corporations and the publication houses to attract consumer attentions, right? It doesn't just apply to the creator of the ad, but also includes the publishers, media houses, marketing agencies, the printers of such material, and even endorsers, right? Many cases, even the endorsers of such advertisements are punished by the court of law, penalized by the court of law, right? These people can be held accountable if they are involved in promoting any of such advertisement at any of the level, be it publication or distribution or otherwise, right? For example, if a company runs a billboard ad showing a woman in, let's say, sexually suggestive pose to promote an energy drink, right? all parties involved. And if this portrait of woman, this billboard is sexually explicit, then all the parties involved in this case, be it the advertiser, be it the designer, the printer, and even the brand ambassador, can be potentially held liable under this section, section 3. So basically section 3 acts as a preventive measure, and it primarily shifts the burden on the advertisers to ensure compliance with the decency standards, to burden upon the advertisers to prove that there was no indecent representation and there was no ill intention behind such representation. Okay. Section 4 talks about prohibition of publication or sending by post of books, pamphlets, etc. Okay. Now, what does this section prohibits? This section prohibits the production, distribution, sale, or mailing of any kind of a material, right? Material like books, pamphlet, papers, slides, films, written or visual materials, all such materials that contains indecent representation of women. Okay. For example, this section is much broader than just advertisements. It covers, let's say, all print and physical media as well, right? It covers all of it. Such material where indecent material can be circulated, even if it's for, let's say, commercial purposes or entertainment purpose or private purpose, right? All are covered under this definition. This term that have been mentioned here, that is sending by post, is a nod to earlier method of distribution, right? But has also been interpreted today, as of today, by the Honorable Court of Laws, right, to cover electronic messaging, emailing, and delivery in electronic form in the modern times. Like, for example, a magazine article containing morphed or explicit images of women, or a self-published book with sexually explicit, let's say, drawings or writings, if sold or if they are mailed to the readers, would be punishable under this section. Okay, they will be made punishable under this section. Now, if we talk about the relevance of this section in the contemporary times, in the modern times, then with the rise of e-commerce and digital books, this section is often applied in tandem with IT laws, such as Information Technology Act of 2000, okay, for online and digital versions of such publications. Okay, so section 4 is very much relevant in modern era, especially in the digital era, right? Digital field. Now section 5. Section 5 talks about powers to enter and search the premises, right? Now, as the title itself suggests, this section gives power to police officers, but not below the rank of inspector, right? This power is available to the person who is or above the rank of police officer, right? What is the power? Power to enter and search any premises if they suspect an offense under the act has been committed, right? For example, to ensure enforcement, the act allows the police officials to act without waiting for the court orders in certain cases, not in all cases, but in certain cases, right? So if there is creditable information that indecent materials are being circulated, printed, stored, distributed, whether it's in office or studio or, let's say, press or warehouse, In all these scenarios, the police officers can conduct a search operation, and if they find any material in there, they can seize such material. Okay. Now, similarly, if the law enforcement officer receives, let's say, receives a tip about a film production studio shooting scenes that degrade or objectifies women, let's say a pornographic kind of a material, right? Such kind of a tip is received by the police officials, then they can inspect such premises and seize all the equipments, arrest as well as seize all the equipments or footages if they find any. Okay. Now, while this power is necessary for enforcement, it must be used judiciously, primarily to prevent harassment or, let's say, misuse by the hands of the police officials. Right. Now, the guidelines under the CRPC Criminal Procedure Code, now the Bharatiya Nagarik Suraksha Sanhita also applies in cases of searches conducted under this provision. Okay. Now section 6. Section 6 primarily talks about penalties. Now what are the penalties? The penalties for violating the provisions of section 3 to section 4, section 3 and section 4 are, in case of first conviction, the person can be punished with an imprisonment up to 2 years, right? And fine of rupees 2000. Whereas in subsequent convictions, the imprisonment may extend up to 5 years, and the fine may extend up to 5,000 rupees, right? So 2 years to 5 years imprisonment and 2,000 to 5,000 penalty may be applicable in case of violation of section 3 and section 4 of the statute. Now, the penalties which are, you can see that the penalties which are given under the law are moderate, but they are significant, right? Particularly in case of repeated offenders, right? Recidivists. The escalation in punishment serves as a deterrent against habitual violations, right? Now, giving the inflation and the scale of modern advertising, right, especially in the digital era, a fine of rupees 2000 to 5000 is quite insufficient, right? It's not that much compared to the scope or the gravity of advertisement that happens as of today. Now, considering there has been repeated demands by the socialists, by the activists, by the lawyers, that this fine amount should be increased, right? And it should include provisions of digital content creators as well, including the influencers and the platforms on which such publication is being carried out. Okay. Now, section 7 talks about offenses by companies, right? Now, if a company commits an offense under this act, then every person who was in charge of and responsible of the conduct of business at the time of offense is deemed guilty, right? Every person is deemed guilty. This is a corporate liability clause, right? This is kind of a corporate liability, corporate accountability clause. Now, this section ensures that not just the company, but also the directors or the managers or any other key official of the company, right, can be prosecuted if they had knowledge, if they are committing the offense, no doubt about that, but also if they have knowledge of the offense, and where negligent has been carried out on part of these officials. So for example, if a media house or an ad agency produces and broadcasts an ad campaign that contains indecent images of a woman, right, indecent portrayal of a woman, right, so not only the organization but also the managing director, the company executive officers, the creative directors, or any other person in charge can be prosecuted, provided the involvement or negligence is proven before the court of law. So, in other words, if a person can prove that the offense occurred without their knowledge, or that they exercised due care, due diligence, right, but still the offense happened, they may be exempted from their liability if they are able to prove their innocence before the court of law. That is again covered under the section. Now, let's talk about some important judgments relating to the statute. No doubt there are n number of judgments dealing with the statute. I have taken a few here, right? As we discussed, Avik Sarkar versus State of West Bengal, the case of 2014. Now, in this case clarified that the deception of nudity is not necessarily absence. Right, the presentation of nudity is not necessarily absence, and it is not necessarily punishable in nature. The court in this case ruled that the photograph of a nude Boris Becker with his fiancée published in a magazine was not absence. Rather strange, right? It's not absence as it did not intend to arouse pursuant interest, right? The Supreme Court in this case shifted from the age-old heckling test to the contemporary community standards test. Okay, that was the case. In another case of Ajay Goswami versus Union of India, the case of 2007, in this case, the petitioner challenged the publication of semi-nude images in newspaper. The Supreme Court held that freedom of speech and expression, which is given under Article 19(1)(a) of the Indian Constitution, cannot be curtailed unless the publication is absence as per the law. It again referred to the community standards, and it suggested that the community standards must be taken into consideration, right? In K.A. Abbas versus Union of India, the case of 1970, although this predates the act itself, its importance for laying the groundwork, right, for the legal understanding of decency and morality in India is important, right? This case is a case which happened before the enactment of the statutes. Look at the year 1970, right? But still this case is important, right? Because this is how the judiciary started to take cognizance of indecent representation of women. And finally, the popular case of Khushbu versus Kinnai Mal, I'm sorry if I'm mispronouncing the name, the case of 2010. So in this case, the popular actress Khushbu was charged under the act for allegedly promoting premarital sex, right? The Supreme Court quashed the charges in this case, and it held that personal opinions cannot be considered obscene or indecent unless it meets the threshold laid down in the law itself. Okay, laid down in the law itself. So these were some of the popular cases relating to the Indecent Representation of Women's Act. Okay, now let's talk about the last part of our discussion, that is the recent developments and amendments that are happening in the field of representation of women. Now, over a far past few decades, the media landscape in India has undergone a dramatic transformation. That is something that we all are witnessing as of today. Where once print newspapers, magazines, or television broadcasts were the primary means of communication and content distribution, today, as of today, we now live in an era dominated by digital platforms, mobile applications, internet connectivity, right? These digital platforms include social media applications like, let's say, Instagram, Facebook, YouTube, X, or previously called as Twitter, or they also include over the top, that is OTT platforms, right? OTT streaming services like, let's say, Netflix, Amazon, Hotstar, and many more, right? They include other type of mobile apps. They include the influencers who are running the podcast, or they are carrying out some kind of a show on the digital platform, right? And the most recent development in the digital area, that is AI generative images, right? Generative AI, right? All these have come within the preview, are the recent developments, and they either have come or are required to be brought under the preview of the Indecent Representation of Women's Act, right? Now, this shift from the traditional publication and distribution to the digital publication and distribution has brought with it a new set of challenges in, let's say, regulating indecent representation of women, right? Or prosecuting the people who are involved in such publication and distribution. Unlike traditional media, which is relatively easy to monitor due to, let's say, central production houses and distribution channels, digital platforms, on the other hand, are highly decentralized, right? They are rapidly evolving and are kind of user generated in nature. Anyone with a simple smartphone can, as of today, can create or edit or share content very instantly. That is something that we all can witness as of today. And this activity by a person often bypasses traditional editorial or regulatory filters. Now, recognizing indecency under the Act of 1986, in addressing these new mediums, a draft amendment to the Indecent Representation of Prohibition Act was proposed in the year 2012. So the government took cognizance of these recent developments, right? Not recent as such, but some digital developments in the year 2012, and they proposed amendments to the Indecent Representation of Women's Act, right? This was rather an important step towards modernizing the law in line with contemporary digital realities, digital requirements, right? If we talk about some of the key highlights of the draft amendment of 2012, then the first one is inclusion of digital and electronic media, right? Inclusion of digital and electronic media. The amendment of 2012 sought to explicitly cover digital formats, including websites, mobile apps, right? Streaming services, OTT platforms, and various other social media platforms. This was very much crucial because until the amendment of 2012, the original act only focused on print and physical forms, and in some cases, up to some extent, the visual forms, right? Like we saw of let's say a signboard, right, or the neon lights, that was covered under the statute. But the new amendments, the new ITM ideas were covered under this amendment. The second important aspect of the draft of 2012 was enhanced penalties. Now, the proposed revisions suggested increased fines and longer imprisonment terms, right? Especially for repeated offenders, recidivists. This was to serve as a stronger deterrent. No doubt, the objective was to punish the wrongdoer, to impose heavy penalties upon the wrongdoer, but also create deterrence among the people, right? Deterrence among especially the commercial entities, right, and individuals who are using digital platforms for mass distribution, right. The third important idea behind the draft bill was establishment of central monitoring authority. Establishment of central monitoring authority. A centralized body was proposed to track, investigate, and penalize violations, particularly in online spaces. Okay. Now, this body was also expected to frame content guidelines, then receive complaints, and act as a coordinating agency, right? Agency between police, cyber unit, and content platforms, right? So this body had lot of power in the digital era. But unfortunately, while these suggestions marked a progressive shift, they have not yet been enacted into law, right? However, many of these concerns, they rise, uh, are now being indirectly addressed through other existing statutes and regulatory frameworks, and many a times by the court of law itself, right? There are so many different precedents relating to digital uh, indecent representation of women. Okay. Now, if we talk about the interplay with other laws, then since 1986, the Act hasn't yet been updated, right? To updated to include or to reflect the digital realities, realities that we are seeing as of today, right? Several other legal provisions are often invoked to address indecent representation of women, right? Provisions such as Indian Penal Code, the section 292 and 293, that is something that we discussed. These sections basically deals with obscenity and criminalizes the sale, distribution, and public exhibition of obscene material, especially to minors, right? Again, they are often used, these sections are often used in conjunction with many other statutes, right? Statutes involving magazines, videos, or digital contents, right? Then there is Information Technology Act, the Act of 2000. Under this act, section 67, right, basically deals, section 67 is critical. It is critical in case of online platforms, right? Now this section 67 basically penalizes publication, transmission, and causing transmission of obscene material in any kind of electronic form. This section has a penalty, a heavy penalty rather. The penalty that is provided under this section is up to 5 years imprisonment and fine. Okay. This section is seen to be commonly used to address violations on websites, social medias, and file sharing apps many a times, right? Now there is one more statute, that is the Cinematography Act of 1952. Right, the act governs the certification and censorship of films by the Central Board of Film Certification, CBFC. This is the word which we frequently used when it comes to the movies or curtailment of scenes in any movie. Right, now films that contains scenes which are deemed to be indecent or objectionable in nature, objectionable from women's perspective or the society's perspective, may be refused. They may be refused certification, or it may be or the board may ask the producers to edit the content, to cut the scenes or edit the contents of that particular scene, particular movie, right? And last but not the least, there is protection of children from Sexual Offences Act, that is POSCO Act of 2012. Right. This is something that we are going to discuss in detail in my next video, but here I have given a highlight. Now this act uh, does not focus solely on women, but this POSCO Act prohibits the sensationalization of women in sorry sexualization of women of children in any media, in any form, in any digital form, right? Or this sexualization of children or the uh, pornographic contents relating to children are a rising concern in basically primarily in influential culture and the digital advertising era, right? So it is quite a serious issue. Now if we talk about the real world data and trends, according to the report by the National Commission for Women, NCW, over the past few years more than 500 complaints were received related to indecent representation of women, primarily through digital and print media only. Right. Now, these complaints include mm, various aspects like various issues like objectionable advertisements, sexually suggestive videos or memes on social media. Then there is the serious rising of deep fake contents, right? Or the photoshopped or doctored images shared without the consent of the original owner, right? And so many more. Now, the Ministry of Women and Children Development, one of the very prominent ministry working in the field of women and children. Now, this ministry has acknowledged the growing problem and has repeatedly emphasized the need to update the act and regulate online content, which is now the primary site of concern. If we talk about the emerging areas of concerns in digital era, then one is social media platforms, the most serious type of uh, digital development, digital places where you frequently see, right, all sorts of indecency, at least as of today. Right? Platforms like Instagram and TikTok are filled with contents that often skirts the line between expression and objectification, right? Many of the influencers, right, either knowingly or unknowingly, I don't know, right, share contents that commodifies the female body of for views and for sponsorship, right? OTT contents, uh, especially the web series and films released on these OTT platforms, often lack stringent certification process, right? The certification process which is applicable to theaters but not to OTT platforms, and this leads to increase in explicit or indecent portrayal of women, right? Then there is again influences, right? Uh, Influences with brand endorsements, now commonly done by influencers by through their videos or by storytelling or by way of interviews. This is a little regulation or oversight on how women are depicted in sponsored content, right? That needs to be controlled. Influencer marketing, right? And finally, there is the newly emerged serious issue in the digital platforms is AI and deep fake technology, a new wave of concern, right? AI and deep fake technology, AI generated content or deep fake morphed images, right, of women, right, into, let's say, pornographic or humiliating imageries often shared are seen to be often shared on various platforms, right? This many a times result into unnecessary harassment or even in some cases blackmailing of that woman. So despite being brief, if we talk about the statute as a whole, then despite being brief and seemingly outdated act, the Indecent Representation of Women's Act of 1986 has gained renewed relevance in digital era. Its core objectives, protecting the dignity of women, remains crucial, but the tools and techniques to fulfill this objective must evolve. That has become need of time. Now there is an urgent need to amend and modernize this law to reflect the digital first world we live in today, right? We live in a digital era as of today, right? The era where content spreads very fast, very rapidly, anonymously, and it causes severe harm to the person, to the targeted person, to the minds of the people, of minds of the viewers and society at large. So concluding this session, the I can only say that the Indecent Representation of Women Act of 1986 is a landmark step, right? No question about this. It is something protecting the dignity of women in public discourse. While the intention behind the law remains strong, the implementation and its reach needs to evolve with the changing time, right? Especially in the digital era. There is a pressing need for stronger enforcement mechanism, integration with cyber laws, sensationalization of media producers, and not last but not the least, greater awareness among the public. As consumers of media, somewhere, somehow, we also bear responsibility in questioning the content that objectifies or degrades the status of a woman, especially in the society like India, right? The legal reforms backed by social consciousness can be seen as a way forward, right? So with this, I conclude my session here, and I thank you all for watching. Uh, with this, I think I'll conclude. The next video will be on POSCO Act. Okay. Okay. Thank you.